Today, we are going to take a look at a decision from Germany, from the District Court of Munich, that was delivered in the fall of last year. And it's a case between Nokia as the claimant here in these proceedings and Amazon as the defendant. The court focused in this decision particularly on the behavior and the conduct of the parties, and it looked through the respective requirements that are set under European law. It looked at, for example, the notification of infringement. It looked at the SEP owner's offer, and also at the issue of willingness, meaning what to be expected from an implementer that has been notified that he uses standard essential patents and needs a license for that. The court also dealt with the issue of proportionality. We're going to take a look also at that at the end of the presentation. Let's take a look at some background of this case, as we always do. We don't have a very detailed, let's say, description of what had happened here, particularly before the proceeding started, because a lot of the relevant parts of the decision have been redacted. But what we can say generally is that Nokia approached Amazon with information about its portfolio of standard essential patents. Maybe interesting to note here, we're talking about video coding patents, HEVC, particularly here, and shared also a list of patents, and did that a second time before the parties entered into the litigation, and made also at least one offer before litigation started. Now, there was no agreement, of course. That's why we ended up in court. Nokia filed the case in October 2023 before the District Court of Munich in Germany. There was also some other venues that have been entrusted with the case. Maybe for us interesting here, just to keep in mind, there were also proceedings in the UK, in which at some point during the litigation, Amazon also required the court or asked the court to make a front determination. So just keep that in mind. An interesting fact that happened during the proceedings before the District Court of Munich had literally not anything to do with the proceedings itself, but was a parallel development in Germany, which played a role here in this decision. That's why I'm mentioning it. And it is a decision of the European Commission in April 2024, so almost half a year after these proceedings were launched, to file an amicus curiae brief in other proceedings before a different court, to be more precise, before the High District Court of Munich here. Why was this important? This was important because in this amicus curiae brief, the Commission laid down its views on how to interpret the behavior and the conduct duties that have been laid down by the Court of Justice of the EU in the Huawei CTE decision before, and had also asked the High District Court of Munich to make a referral of these questions to the Court of Justice of the EU. Now, although this intervention had not taken place in the proceedings at hand here, it was not something that directly impacted these proceedings. It was, however, very much discussed in this case because particularly the defendant used the Commission's views or the Commission's positions to argue its case here. And that's why we also had some feedback or some input of the court regarding that element. We're going to see that in a moment, but just here to keep in mind that this happened during the proceedings, and although it did not, this intervention, this amicus curiae brief was not in these proceedings particularly, it was something that was discussed here and was addressed by the court. Nevertheless, the proceedings moved on. And in September 2024, the Munich District Court delivered its decision. And it was a decision which was very much in favor of the claimant here. The court, among other remedies, also granted an injunction against Amazon. Then we didn't have an appeal decision here in these proceedings. We didn't really move very much forward in appeal in this case because in March this year, in March 2025, Nokia and Amazon announced a settlement which ended all pending litigation, I assume, including these proceedings here. So this means that from this case, we will most likely not have any further court decisions because the litigation between the parties has ended. Now let's take a look at the reasoning of the court. As always, of course, we're going to focus on the front-related issues. We are not going to focus on the fact that the court found here that the patent that has been asserted was infringed, so infringement was established. And then the court had to turn to the defenses of Amazon, that Amazon had raised against an injunction and against other exclusionary measures. And it was primarily a front defense, which we're going to deal mostly in this presentation today, and also a proportionality defense, which I mentioned earlier. And we're going to, again, look at the end of the presentation. But before going into that, I think it's very interesting to see the court's thoughts on which should be the applicable standard here regarding the assessment of the parties' behavior during the negotiations. As I mentioned, in this respect, the amicus curiae brief of the Commission in these parallel proceedings before the High District Court of Munich played a big role. And the court dealt with the arguments that the defendant tried to raise out of this amicus curiae brief. And at the end of the day, the conclusion that the court had was to say that the views expressed by the Commission conflict with the views of the Munich District Court, but this did not provide a reason to alter the case law of the Munich District Court. So in a sense, the court said, I acknowledge the fact that the Commission has different views here, but it was not convinced by these views, and it did not take these views or the positions of the Commission as an excuse to change the standard that it would apply in these proceedings. Now, if we look at the reaction of the court to the amicus curiae brief, the court had doubts on two different levels. So the first level was the question of whether such an intervention was needed at all. And as we're going to see in a moment, the court questioned that. And the second was more on the merits, so the actual positions and views of the Commission. And the court also, as we're going to see in a moment, found that they were not convincing here. They were not in line with the Huawei ZTE decision of the Court of Justice of the EU, particularly. Regarding the first aspect, whether there was a justification to make this intervention at all, the court in Munich found clearly that the amicus brief lacks sufficient legitimization, because the court held here that the legal requirements under which the Commission is entitled to make such intervention in pending court proceedings were not met here. This is laid down in Article 15 of the Regulation 1 of 2003. And what is the main reason, in simple words, to make this intervention that is being established in this provision? The main reason is to try to secure that this law in Europe is applied in a uniform and harmonized manner. And this is a little bit the excuse that the Commission had also used here for the amicus brief by saying there is a problem in Germany, particularly because the district courts of Mannheim and the district court of Munich apply diverging legal standards when it comes to front cases. So we need to have a harmonization based on the views that the Commission expressed. Now, the court here in Munich, it was not convinced by that. It found that it was highly questionable that there is indeed a discrepancy between the case law of the Mannheim and the Munich District Court, and that these courts, both German district courts, applied diverging legal standards here. Because the court noted that the Commission did not refer at all in its statement, in its amicus curiae brief, to the standard which both courts applied, which was a standard that the Federal Court of Justice, the highest court in Germany, had established back in 2020 in the civil hire cases. And the court said, this is what we are uniformly applying as district court in Germany. This is what we are looking at. And the fact that the Commission did not refer to this case law at all in its amicus curiae brief was criticized by the court here. What the court also criticized was the court to which the Commission addressed its amicus curiae brief, which was the Munich Higher District Court. Because even if you would argue that there was a problem with harmonization, the court noted here that the Munich Higher District Court would not be the right addressee to rule on or to produce this harmonization effect, because its case law would be binding only for the Munich District Court. If there is a potential divergence, what you should have been done is to address this to the Federal Court of Justice, which would then be the one court which both the Munich and the Mannheim District Courts would need to follow. So in total, the court had serious concerns whether this attempt to exert influence over the principle of separation of powers was justified here. And it found that if you have the executive branch, like the European Commission in our case here, intervening in court cases and intervening with the judiciary's work, then you should provide grounds and you should have sufficient grounds, and this requires substantially higher efforts in the eyes of the court here. Apart from that, of course, as I mentioned already, the court also did not find the position that the Commission took convincing, so that at the end of the day, it also agreed with other courts. For example, we had similar statements by the UPC in the meantime, that a referral to the CJEU is not required. Looking at the individual obligations that have been established by the Huawei ZTE judgment, the court generally found that the views or the positions of the Commission were very strict and did not really meet the spirit of the Huawei ZTE decision. For example, regarding the obligation of the patent owner to make a notification of infringement before going to court, the Munich District Court found here that the Commission would impose considerable requirements, which would be very strict and would ignore the nuanced case law of the Federal Court of Justice in Germany with no obvious reason. Regarding the second obligation, which is an obligation of the implementer to react to the offer to notification of infringement and express willingness to take a license, the court also criticized the very formalistic view that the Commission had taken, which basically said that this is just a solely formal factor that you need to consider, so you should not read too much into that. And the court pointed out that the Commission itself said that this notion that it's only a formal element is not directly derived from the Huawei ZTE decision, which made the court question whether this is something, whether this is an argument that corresponds to common legal approach. So the court, on the contrary, found that this is rather a conviction-led interpretation, which cannot really have merits. And finally, when it comes to the next step in the Huawei ZTE judgment, which is the obligation of the patent owner to make a licensing offer, here the court criticized the Commission's tendency to basically focus all the analysis on the SEP owner's offer and putting the behavior of the implementer a little bit in the background, because the court said here this contradicts with the negotiation maxim which the court established in Huawei ZTE. So this was also the court's criticism here, saying that this is something which does not correspond with the spirit of Huawei ZTE, which is exactly aiming at facilitating good faith negotiations in which the parties can form front and reach a front agreement. So I'm going to take a break here for a moment. Now, having said that and having basically confirmed the standard of analysis which is going to be applicable in the present proceedings, the district court moved on to examine the front defense that Amazon had raised. And here in Germany, the front defense is regularly viewed from a competition law angle. To put it very simple, the argument is that an injunction or other exclusionary measures should not be granted because by filing an action that could lead to the exclusion of the implementer from the market, the patent owner abuses a market dominant position. So this is the basic argument that under which the front defense is being treated in German case law. And this is what happened here as well. Now, the court, of course, had to take a look at first the question whether there is at all a market dominant position on Nokia's side here. And the court confirmed this basically by looking at the technical aspects of the patent in suit. So it said there is a market dominant position because the teachings that the patent protects must necessarily be used for applying the standard. And from a technical viewpoint, there is no possibility to replace that, or there is also not indication that there is an equivalent technical alternative. So here the dominance question was solved basically by arguing with the essentiality of the patent that has been asserted. Nevertheless, although the court found that there is a market dominant position here, it found that Nokia did not abuse this market dominant position, so there was no room for denying an injunction here, particularly because on the one hand, Nokia, in the eyes of the court, had met its obligations under the Huawei ZTE ruling, whereas on the other hand, Amazon had lacked willingness to obtain a front license. Now, looking at the obligations of Nokia, the court looked at whether there had been a sufficient notification of infringement here in the present case and found that yes, this was the case. The court mentioned that Nokia had sent an email with a list of patents that are potentially essential to the HEVC standard, which included also the patent in suit. And it sent this list twice, once in the beginning of the negotiations and then a second time before filing the lawsuit. And the court found that by that, Amazon became aware that there are standards compliant products that infringe the patent in suit, and that negotiations should start regarding a license to these patents. The court found also that the fact that Amazon did not request further specifications regarding the infringement also indicated that the information that had been provided was sufficient. So in general, there was no real doubt here expressed by the court that the notification of infringement was sufficient and that sufficient information was shared with Amazon before the proceedings started. Then the court did not really go directly into looking at Amazon's willingness, but looked at the other obligation that Nokia potentially would have here, which would be the obligation to make an offer to Amazon on front terms. Now, the court looked at the offers that Nokia made and found that they were an appropriate basis for negotiation. So in the eyes of the court, this meant that insofar also Nokia did not breach any of its obligations under the Huawei ZTE framework. Looking at the very first offer, which was an offer for a lump sum rate, the court found that this was an offer which was within the front range. And looking then at the further behavior of Nokia after this first offer and the next offers that Nokia had made, which were partly adapted, there was also a change at some point to a running royalty regime. But just the fact that Nokia adapted its offers in the eyes of the court indicated interest into signing a license. Generally, what the court made clear here is that the front rate is not a fixed amount, but it's rather the result of a negotiation process. meaning that it's something, front is something that needs to be developed by the parties in negotiations, which means that the specific characteristics of the parties must be considered in the negotiations and the player role, the specific circumstances of its case, which means that it can be that you have different outcomes for different licensees. The court said, however, here you have to be aware that the differences not discriminate specific licensees, but generally, I think the important message here is to say that that front and also determining a front rate, setting a front rate is the result of a negotiation process in which both parties need to engage. And the court said here, this is expressed also by the fact that you cannot have the front defense being successful if the first offer exceeds the amount that's actually expected. So if it is a process, if the front is going to be determined in a negotiation process, then it's clear that if the first offer is a little bit more than you have expected, this is not sufficient enough to establish a front defense. Especially the court said here, there is no issue when the offer lies within the acceptable range. And how to determine this range? Interestingly, the court said here, to determine what would be the appropriate range for the front rate, you also need to look at the negotiations of the parties, and you also need to take recourse to information gained in the subsequent negotiations. What you need, for example, to look at are comparable licenses, which in the eyes of the court regularly are decisive for fixing the concrete amount. You have to look at the figures of the parties. So you have to determine the range also based on the parties' negotiations and the specific circumstances of the case. Looking particularly at cases where you had a lump sum offer and then you had a change and then you had an offer for a per unit royalty, the court said, well, you need to also look at that more holistically. For example, the per unit rates that you offer can be relevant for assessing the reasonableness of a previous lump sum offer, but you have to take other facts into account. So if you had initially a lump sum offer, which was the case here, and at a later point in time, you changed the calculation method and used a per unit calculation, you can use the per unit price later on offered to assess whether the lump sum offer was front or not, or was within the range or not. But you need to also take some other factors into account. For example, that a lump sum license offers a more simplified contract execution. And you should also consider the forecasting risks that you get into with a lump sum offer, particularly, for example, that the sales evolve much better than forecasted, which would mean that you would eventually have lost money compared to a per unit rate model. So all of this, again, at the court here, indicating that the determination of the front and the fixing of a front rate is a process that needs to take various aspects into account. And apart from that, the court mentioned also some other factors that can be relevant. And it started by timing. The court said the time when the parties agree is a key aspect of front rate setting. And this applies both for new and established standards. The basic idea behind that is to say that signing an agreement as early as possible is beneficial for the licensors, for the patent owners, because this gives them the potential to use the money they receive from the license and invest this in new research and innovation projects, considering particularly the fact that in the standardization field you have heavy upfront investments that are reliant to licensing income, more or less. The court also clarified here that this idea, this main notion, applies also for non-practicing entities. So the earlier the signing, the more beneficial it is for the patent owner. Then the court also said, of course, the factors that you also need to consider are, on the one hand, the patent portfolio, of the licensor and the product portfolio of the licensee. And the court addressed one particular scenario here, a case where the patent owner has patents which read to different standards. And in this case, the court said, one license covering all or multiple standards would regularly serve the parties' interests. So if you have different standards and you have products that needs license to all of these standards, it's usually in the interest of parties to have only one license agreement signed. But this is not necessarily always the case. The court said in complex situations, you can have a structured licensing, and this could be advantageous for the parties. You need, again, to have a case-by-case assessment. And what could be this type of complex situation? The court indicated that by saying that an important factor to also take into account is whether there's an existing licensing practice. And here the court said an existing licensing practice in a specific segment of the products of the potential licensee can allow the implementer to can allow the patent owner, to offer only a license limited to this specific segment, whereas a license to another segment of the products of the licensee where no licensing practice has formed yet could in principle be rejected, at least temporarily. So here the court said, in other words, if you have the scenario where the patent owner has different product segments, which all need a license, but there is an established practice only regarding one of the segments, it is on the patent owner's side to decide at first to license only products for which a licensing practice exists, which vice versa also means that the implementer has not claimed to a comprehensive license from the beginning. And the reason is that the court thought that if you would allow the implementer to force a license that would cover both segments, so both the one segment that already is being licensed and there is a practice for that, and the other one as well, you might generate bundling effects in favor of the implementer, which would eventually lead to a discrimination towards other competitors which operate in this one segment that is not being licensed yet, which should eventually be avoided here. So you should not provide the implementer with a claim to have a comprehensive license covering every part of every segment of its product, even those for which a licensing practice has not formed yet. And to be more precise, in the present case, there were two segments of Amazon that would be potentially needed a license. On the one hand, it was HEVC compliant end devices, so the hardware that that Amazon sells. And insofar, the court said there is an established licensing practice. So if you're looking at HEVC compliant products and end devices, you have other licenses already granted. You have Nokia having licensed already this type of hardware, and this has been proven by third-party agreements that Nokia presented. But you have also licensing for this type of hardware over patent pools. Where you don't have a respective license is the other big segment of Amazon that would need eventually a license under HEVC patents, which are the streaming services. So here the court said regarding the streaming services, there are a lot of questions open for the moment. For example, what would be the calculation basis for royalties, the user numbers or the actual use? This is still an open question. And there are other questions as well. For example, if the license to end devices would also cover the streaming services. The court questioned that, but it said these are open questions. So this meant here at the end of the day that a license that would cover both segments, both the end devices, the hardware, the HEVC compliant hardware, and the streaming services, was not a necessity here. So you could not, as we're going to see in a moment, Amazon had no claim to get such a license. Respectively, Nokia was not obliged to provide such a license. Then another interesting element was the court saying here that litigation cost is something that is also a factor to be considered when you're doing when you're setting up the front rates, and this applies particularly when it comes to lump sum offers, because the court said that especially at the start of negotiations, patent owners, as a rule, factor in potential litigation cost. And this can not be marginal. It can have a significant weight, especially in multinational disputes. So the court made this clarification here that litigation cost can be also a factor that you need to include in the front assessment. And this is something that is not per se excluded from this analysis, or should not be excluded from this analysis. So in all, the court concluded that Nokia had met its obligations, especially the obligation to provide an offer on front terms, because the offers that it had provided were a sufficient basis for negotiations, were a sufficient starting point for licensing negotiations. And the fact that Nokia did that and provided that and adapted the offers and negotiated further was sufficient in the eyes of the court to meet the obligations under the Huawei ZTE framework here. Having said that, the court looked then at the Amazon's behavior, and especially here the question whether Amazon had been willing to accept an offer and obtain a license from Amazon, from Nokia here. And the conclusion here of the court was to say that Amazon was not willing to obtain a license. The court found that Amazon pursued a deliberate delay strategy, particularly because the court had the impression that Amazon refused to sign a license which would cover the one segment of its offerings. I think the court referred here to the end devices, where you have already a licensing practice, with the overarching aim to get a license covering also the other segments. I think here again the streaming services were meant, for which Nokia has no offering yet. The court found that the negotiations between the parties were largely defined by Amazon's insistence to license also the other segment of its business, which is likely the streaming services. And the court found that this was problematic because, as we said already, there is no respective claim for Amazon. So Amazon has not a claim to have licensed all of the segments in which it offers or which it makes business, especially since we've seen already the court found that if there is a licensing practice in one segment and no licensing practice in the other segment, the patent owner is in principle in the position to offer, at least at first, a license covering only the segment where you have a licensing practice that has been accepted in the market so far. So the court said that there was no claim for Amazon to insist on having this comprehensive license covering everything that it offers. And it added here that, of course, it's on the patent owner's side to determine how to license, and it is in principle allowed to offer different licenses to different standard users. The court also, apart from saying that there was no claim for this comprehensive license, it found also that from a commercial, maybe more from a commercial point of view, there was not a good reason why you should have one agreement here, only one agreement signed between the parties. Amazon apparently argued a lot in the proceedings that its products, both segments, have or are following an overall concept which requires one single comprehensive license to be granted. Meaning that they are, so if we want to put it in very simple words, the argument is here to say that, look, the two different segments, the end devices, the hardware, and the streaming services are so tied to each other that it is basically required to license them jointly. The court looked at the arguments and basically noted here that if you look at the end devices and if you look at the services, the streaming services, there is no real technical connection between these two segments, meaning that the products and the services that Amazon offers and use the HEVC standard are compatible with third-party offerings. So you can use, for example, the hardware, the HEVC compliant hardware that Amazon offers to use also other, to also stream services of other offerings. But on the other hand, you can use other type of hardware to use the streaming services of Amazon because they are compatible with each other. So the court said here there is really no technical connection that creates this overall concept which would require one single comprehensive license here, because the only connection is the fact that these two different segments are offered by the same vendor. And this, in the eyes of the court, was not enough to say that one license was required here to cover both segments because they are so tied to each other. So the court was not convinced by this argument. Then there was some discussion of how to deal with the fact that there is still no licensing practice for streaming services, and whether you can extract any arguments out of that. The court said here, generally, the fact that there is no an established licensing practice for streaming services does not create a claim of potential licensees that this should remain unchanged in the future. In other words, the court said the fact that until now there is no established licensing practice for streaming services does not create the presumption that there is no license needed, or that licensing the hardware also covers the streaming services, or that the streaming providers, it has been a strong practice in the market that they don't need a license at all. So again, the lack of a licensing practice in the eyes of the court did not have any impact on the fact that this could change and that licensing in this field could be established in the future. It did not exclude the fact that you could create a licensing practice also regarding this specific segment of HEVC compliant products and services in the market. Then there was some discussion about the agreements, the third-party agreements, the comparable licenses which Nokia had produced in the proceedings here. And in general, the court was not also very much satisfied by the way that Amazon had positioned itself in this respect. So the court found that Amazon did not deal constructively with the third-party licenses disclosed. What Amazon had done predominantly was to argue that the licenses were not comparable because they were signed with licensees that were much smaller than Amazon and therefore were not representative, etc. And this type of arguments was the main part of Amazon's pleadings. The court said here, yes, even if you look at that, it might be true that some of the licenses are not comparable, but definitely there are several agreements which are comparable. And these comparable agreements clearly indicate that the market accepts Nokia's price expectations, which consequently would mean that Amazon should have made a respective offer here, which was at the end of the day not the case. So apart from this fact, the court also criticized that Amazon continued requesting further licenses to be disclosed, allegedly signed with similarly situated licensees. So on the one hand, the court was not satisfied by how Amazon had used the licenses that it got and what type of arguments, what type of an analysis it had applied on these agreements. And then it was also not very much satisfied by the fact that Amazon constantly asked the court to order Nokia to produce more and more license agreements. The court said that in principle, it is the patent owner that can select which licenses to disclose. What it is required from the patent owner is only to inform whether the contracts were signed under the threat of a cease and desist order and whether other licenses exist. On the contrary, the court said that in cases where you have already a number of licenses being disclosed, the request for disclosure of further licenses can typically be seen as a holdout behavior on the side of the implementer. So the court was again not only not convinced by this request, but it seems to see an indication of potential holdout behavior into asking for more and more information, more and more licenses to be disclosed without eventually having treated the agreements that have already been presented in a decent manner. Then there were two other aspects that it's worth looking at. There was a discussion of whether you can use pool rates as a benchmark for the offer or a counter offer in these proceedings here when we're talking about a bilateral license. There was some argument here, if we're going to put it again very simple in a nutshell, that Amazon said there are pools that have been formed regarding the HEVC standard, and they cover a very large part of the stack of standard essential patents. And if you compare the overall stack that these pools cover and for which you pay a specific amount, and compare that to the share of Nokia of this stack, then you come out with fees, a percentage which is very, very low. And the court said here, this way of thinking is not appropriate. Using generally the pool rates as a benchmark for bilateral offers or counter offers is not appropriate. What is the right thing to do? What is the appropriate benchmark? It's the licenses which have been signed by the patent owner with third parties. If we look at licenses that the implementer has signed with other patent owners, the court had some doubts whether they can directly be, let's say, as useful as the licenses that the patent owner has signed with other licensees. The court nevertheless said that the licenses taken by the implementer can at most be used indirectly to check whether patent owners' contracts are collectively at a high level. But again, the proper benchmark, according to the District Court of Munich, are licenses that the patent owner has signed with third parties. So this is the source that you should look at. And finally, the last element here, where there was some discussions of how to deal with that, how to look at, how to see that, was the fact that Amazon in the UK proceeding, as we mentioned before, had raised a rate-setting counterclaim. The question was how to deal with that, because of course you can say on the one hand that if you ask a court to determine the rates of a license that you would then take, then this indicates that you are willing to take a license. But is this sufficient here in the present proceedings to establish Amazon's willingness? That was the question, more or less, that was posed to the District Court of Munich. And the court found that it is not the case, it's not sufficient. So this rate setting request that Amazon had filed in the parallel UK proceedings was not sufficient to establish its willingness. On the contrary, the court found that this fits rather into the Amazon's delaying strategy. So it's so more an attempt to delay things rather than a real expression of a real and sincere willingness to enter into a license. What is interesting here to note, however, is that the court did not exclude that this commitment to have a court or an arbitral tribunal setting a rate can, under circumstances, be an indication of willingness. For that, the court mentioned several conditions, however. So it said you could maybe argue that asking for a rate determination can be a sign of willingness, but for that, you need the implementer to declare at an early stage, so the timing is very important here, willingness to seek a final resolution before a court or an arbitration. And you need the implementer to disclose all relevant sales figures you need to be able to make a front determination. And this is also important, a declaration of willingness to pay a security or to make an upfront payment for an undisputed basic amount. So if these conditions are met, then in contrast to the present case in which Amazon did not do anything of that, you could eventually consider such a request for rate setting as an indication of willingness. But again, this was not the case here. So the court just mentioned that, but looking at Amazon's behavior, it did not find any elements that would correspond to these conditions. So this was all with the front defense, which was dismissed, as we said already. And just a couple of words on the other defense that was raised here, which is the proportionality defense. Let's call it the proportionality defense. What does this mean? In a nutshell, this is an argument saying that if you compare the value of the actually infringed patent with the potential harm that could occur for the implementer if an injunction is enforced, actually enforced, so if he would be obliged to leave the market, then if the harm is much bigger and much more significant than the value of the patent that has been infringed, exclusionary measures, especially an injunction, should not be granted or should be limited. And there are several options here. For example, granting a transition period of several months in which the injunction is not going to be enforced. And this is actually what Amazon had also asked here, to have a 6-month transition period in which an injunction would not be enforced, so that they have some time to, let's say, find maybe a workaround. Now, the court said here, no, that the proportionality defense was not really well-founded here. Generally, any limitations of the right to injunctive relief are possible only in particularly exceptional cases, since the injunction is the regular sanction against patent infringement. And what the court noted here is that the implementer, the defendant, is the one that must raise the defense and also establish the relevant facts, which Amazon did not manage to do here. So they argued, for example, that it was an injunction should be withheld because Nokia's intention was just monetization and not protecting their own competing products in the market, but the court did not give much merit on that. But apart from these details, I think the basic notion that we need to take with us from this judgment is a position of the District Munich Court that when you have front cases and you have a front defense under competition law that can in principle successfully be raised, then this proportionality defense will regularly not be available on top of the front defense, with the exception that extraordinary circumstances exists. So as a rule, if you have a front defense and you can argue a front defense based on the competition law angle, you won't be able to also raise a proportionality defense. And the court, looking at the situation where you have a party which has been found to be an unwilling licensee, went even a step further to say that if an unwilling licensee raises a proportionality defense, then this can be seen as something that is done in bad faith. So it's an action in bad faith. So also from this angle, a defense on proportionality considerations would not have much prospect of success. Regarding here the possibility finally to have this 6 months transition period we mentioned before, the court dismissed that as well and had some skepticism against providing this transition period. And one reason was that in the eyes of the District Court of Munich, Amazon had sufficient time to take measures that could make the problem less pressing if there is an injunction and there is an order to ask to cease and desist. But the court saw that Amazon had not done anything. So the basic idea is to say that after you have been informed that these measures could be granted after the action was served, you should have already taken precautions to deal with this risk that you might get injuncted. And you had sufficient time to do that after the action was filed. You had almost a year until the decision was delivered. And asking now for additional 6 months after the decision is there was not considered to be justified by the court here. So again, what this decision also confirms is that the line of the District Court of Munich that a proportionality defense regularly will not be available if you have the possibility to raise a front defense in the proceedings.